announcements. Our next case to be argued is C-230666, and that's State versus Catherine Snyder. Mr. McKenna, would you like to reserve time?
4 minutes, Judge. Thank you.
Okay.
Your Honors, Counsel, may it please the Court. Your Honors, this was an enormous case. I know you looked at the record. It's probably the largest record of a criminal case this Court's ever had, other than a capital case. And I'd like to focus on oral argument, the evidentiary issues, in particular in the first assignment of error in Ms. Snyder's brief. The first big evidentiary error that significantly affected the trial from Ms. Snyder's perspective was the admission of the children's hearsay via the foster mother, Brenda Kennedy. What happened there is 2 months after, right after the death of Adam.
Please don't use the children's names.
I'm sorry. Right after the death of the child, the other children were placed in foster care. And about 2.5 months later, one of the children, M, signed A's name, and then the foster mother asked to explain further, and then she proceeded to act out what happened, and she proceeded to she flipped Brenda Kennedy over, she wiped her behind, put her hand in her face, and then the other child, N, said that he wanted to further show what happened. He laid in the bathtub and said that Ms. Schneider had hit A's head in the tub.
Was there, other than this claimed hearsay statements, was there other evidence that A had been exposed to this feces being smeared on him?
There was other evidence, Your Honor. There was testimony by M and N, and also a Marison Center interview. So there was other evidence presented. But this particular evidence set the framework for the whole case. When you read the transcripts, it becomes very clear that this testimony set the tone for the case. And also, as a result of the children doing this, Ms. Kennedy took M to the Marison Center's interview. So at issue is, the legal issue regarding this is, should it have been in these statements allowed in via excited utterance? And I know the Court knows excited utterance, the standards, very well, but just to review for purposes of oral argument, there had to have been an event with causing nervous excitement. The declarant had to have observed it. The statement had to have been related to the event, but most importantly, in that issue here, the statement had to have been made before time expired for the excitement to subside. And that's the crux of the argument. In the brief, I listed several cases that gives examples of what an excited utterance is normally allowed to be. For example, a contemporaneous statement of a shooting or a house being on fire or something like that. And then there was a case that this honorable court ruled on, State v. Smith, which was a menacing case where the witness did not show for trial, and the state played a police camera interview, and the statement was made 2 hours after the alleged event that caused the excitement. And this court ruled that there was enough time for reflective thought that severed or pinched off the excitement, and said that that was not an excited utterance. Well, here we have the death of A that happened in very early in the fall, in October, in early October, and then the statements here were made in mid-December. So it's over 2 months. And at trial...
Does it make a difference that it was children who were making the utterance? I mean, there is some case law talking about, children who have gone through trauma. They don't tell people what happened until they feel safe.
There is case law for that, Your Honor, absolutely, and I know the state cited those cases in their brief. But in this case, we're talking about over 2 months, and there was testimony during trial that the children were doing really well in foster care. They were gaining weight, they were becoming calm, they were eating, et cetera, et cetera. So just because they were excited when they actually talked to the foster care mother, Miss Kennedy, does not mean that the initial excitement hadn't subsided. You are allowed to get fired up, if you will, when you're talking about something. There is no way that you maintain nervous excitement for over 2 months. This court has said the policy of the excited utterance is that it guarantees that there's less time for distortion or things like that when it's contemporaneous. This simply is not contemporaneous or immediately after. We just don't know if it's trustworthy. Were they excited the day they talked to Ms. Kennedy? Maybe, but that doesn't mean they maintained that excitement for 2.5 months. They could have calmed down in 3 days or a week later.
But there was other evidence of the occurrences that they had expressed in these alleged excited utterances, correct?
I'm sorry, Your Honor, there was other evidence. Well, there was other.
For example, the feces thing, that was, you stated that came out in other testimony.
It did. I mean,
And other statements that they made came out in other testimony as well. I guess where I'm getting is, what is the prejudicial
the
impact?
prejudice, as you're correctly getting at, once you decide if there is error in the admission, if it really was hearsay, was it harmless or not? And you have to, then you get into the kind of the weight and sufficiency. Was the evidence overwhelming? What else did the state put on? And our contention is that this particular testimony for Ms. Kennedy was sort of the big, the set piece of all the state's evidence that didn't involve doctors, because it got the ball rolling. As a result of this, Ms. Kennedy did the Marison Center interview, and she explained in great detail what the children had said. And it was dramatic. I mean, even reading the testimony and the transcripts, it comes across as very dramatic, and I think it impacted the trial and the jury in a very meaningful way.
So let me just ask a question. So the foster mother's testimony was early in the 6-week trial?
Yes.
Okay. And then after that, there were days and days and days of additional evidence. But you're saying that because it happened at the beginning, that is something that the jury would have latched onto?
Well, maybe not that it happened in the beginning, but just that it is a dramatic happening, to have kids act out like that, that is. I'm simply saying that, it was not an excited utterance because of the time, and it bolsters, Miss Kennedy's statement her testimony bolsters the other evidence presented. And that's where the harm is. Because when you read the transcripts, you have the doctor's testimony. Our contention is that once you lose this, it becomes a battle of experts. You have all the state's experts and the defense experts, and then you have children some of the foster children testifying for the state, and you have some of the children testifying for the defense, and they sort of cancel each other out, and you're left with this statement from Brenda Kennedy, and that's where I think, because she's a third party, I think it was prejudicial and not just harmless.
But it was cumulative because of the other testimony that followed, correct?
Well, yes, it would have to be. There was cumulative evidence because they talked about it repeatedly in different things. I'm simply saying that this was important evidence, and it was prejudicial because the other presentations of evidence canceled each other out in the weighing factors. If you weigh the evidence of kids and doctors, what's left that the defense didn't really have was this testimony from Kennedy that was counteracted. They couldn't counteract it. That's our position, and that's why it was prejudicial. The other evidentiary issue that I think that Ms. Snyder thinks is big is the admission of the grandmother's emails. The grandmother, Debussy, she had sent some emails in May to the sister of the defendant discussing various situations at home because she lived in the basement of the Schneider residence. And it was allowed in under 8033, then existing mental, emotional, and physical conditions. It's really, if you look at it, double hearsay because you have the grandmother talking about what mother said to a third party, and the trial court allowed it to be authenticated by Ms. Sayward and then read to the jury by a police officer. And clearly that's hearsay. The question is, should it be allowed in or not under 8033? Ms. Sayward discussed she came to Cincinnati to pick up her son, and that's what the trial court focused on, that it was admissible and that Ms. Sayward could authenticate it. We would submit that it's prejudicial simply because the state couldn't cross-examine Grandma.
So, okay, I read the email several times, and did any part of the email go to any element of the charged crimes?
Well, yeah, I mean, you could argue that it did when she said, no, I don't think it did. It went more towards bolstering the case. It went to the grandmother observing that Kate said she wanted to, quote, kill the kids. She was over-disciplining the kids. So maybe it went to, you could say that was for child endangering, towards the child endangering elements of causing harm to the children. In terms of what happened to A, probably not. And I just don't see the purpose of why it was put in except to slander or make Miss Schneider look worse.
If hypothetically we were to agree with you, tell me what, since it didn't go to any of the elements, what's the prejudice? And by the way, your time is, you have 4 minutes left. Since I am asking you a question, I'm going to let you, I also give the state a few extra minutes if they need it.
Thank you, Your Honor.
If the state needs it.
Thank you, Your Honor. I think the prejudice is that the evidence here is so close. When you balance it with what the state presented and what the defense presented, the defense put on a very active defense case in chief. So now you're left with small things for the jury to weigh as to what happened. And when they hear from Grandma that Kate's saying, I want to kill the kids, and she's over-disciplining over toilet issues and things like that, that it could lead it could be the one piece of evidence that may perhaps swayed the jury to find guilt. Thank you, Your Honor.
Okay, thank you.
Thank you, Judge.
Thank you.
Good morning, Mr. McKenna, Your Honors.
Good morning.
I also, just as an introductory, I wanted to say that this case was an incredibly well-tried case, considering the complexity of the issues, the amount of evidence, and the time it took. I think when the record is reviewed, you'll find that the trial court was very meticulous in making rulings, making a record, listening to the attorneys, holding sidebars when necessary, and that many of the assignments of error say there's an abuse of discretion by the judge. I think what you're going to find when you review that record is there is nothing in the judge's rulings as unconscionable, capricious, or arbitrary.
Can you address, so after the Supreme Court's Hartman case, the landscape with other acts, evidence, what completely, it didn't change necessarily, but it was definitely clarified, and courts looked at it in a different manner. Can you address the issues that your opposing counsel addressed as far as let's start with the email.
Okay. Now, they never did claim 404B.
Okay, I'm sorry. All right, you're right. But, yes, all right, go on.
The thing that I think is important about that email, it discussed, if you break it down, abusive language, screaming and yelling by Kate. Also saying Marie and Allie screamed and yelled at the kids. There was a statement that Kate said she wished they were dead. And it said that this was all over potty training. And the mother just couldn't believe that this much drama was over. She said if she would just leave it alone, it could resolve itself. Well, those issues, all of that was corroborated by other witnesses. But the email did not mention hitting, It had nothing to do with the harm to AS. It did not say the words they told MS over and over again, they hated her. Did not talk about not feeding, cold showers, any punishment, taping AS's glove to his hands, isolating him in a playpen. None of that was included in that.
It did say that, that Kate, or I don't remember if it was Kate or if it was both parents. It did say that they abused the children.
Had-
What is your reading of that?
Well, she did say they're being abused. And then, but the only thing she went into in this explanation was screaming and yelling and taking the potty training issues way too seriously. And I think what you got to remember, what you need to remember in all of this is, when MS and NS, they did have their Mayerson interviews, and Ms. Hicks was cross-examined about that. You know, it said NS couldn't even be interviewed. But then when the children testified, and they were 12 years and 14 years old, they were thoroughly cross-examined about all of these things. And what they brought out was so much more than anything was in that email. I don't think the email was determinative of the outcome of the case at all.
So if I'm understanding you, would you agree that many parts of that email were not excited utterances? Because that was the rule under which the trial court admitted it, correct? Or no, it was state of mind, I'm sorry. It was state of mind, I'm sorry, I'm confusing the two pieces of evidence. So it was state of mind.
Yes.
Would you agree with me that several parts of that email did not go to the state of mind, rather it went to the reason for the state of mind?
I think the only thing that went to the reason was her saying potty training. But the majority of what she said, which was present tense, was saying, here's what I'm so upset about. The one thing that potty training was one of the reasons she gave behind it. And I know present sense impression is allowed in for the speaker's impressions, but you're not supposed to get into reasons behind what the speaker said.
So what the speaker in this case was saying, she started with something about how she's so upset, and ended with something has to be done, help. But the parts where she is describing why she is so upset, is that also a present sense impression? Or
I think in the context of this email it is. When you break it down and said, was anything explaining, underlying what she had stated, saying it's all over potty training issues, I guess you could say that was underlying it.
okay, thank you.
Can I turn to the excited utterance component of the argument?
Yes.
The cases that I'm aware of, or been made aware of, that have expanded the scope of this excited utterance rule, all deal with children who are victims of sexual abuse.
Or physical abuse.
Now, the two children who gave the excited utterances were describing something that happened to the other child, not themselves. Is that right?
MS also described what happened to her. She made statements about Marie hitting her and giving her a black eye, the parents saying that they hated her, they liked the other kids better. She went into detail about not being fed, being given the ice-cold showers. Is this what you're...
Well, I guess that kind of goes to my point. Are the excited utterances limited to what the child who was the victim experienced, not explaining what happened to another child?
She explained, like MS explained what happened to her. NS explained everything that he saw. Now, in State v. Lukacs, that was a first district case that reviewed a lot of these cases. The victim was a child named Vanessa. Her brother was able to testify. And it was all the things that he thought happened to her, or that he said happened to her. So it didn't have to be him only testifying about what happened to him.
Well, what was the brother was actually testifying as to what he saw, not a third party testifying as to what the brother told them, which is what we have in this case. Is that right?
But that, yes, but that points out how it is cumulative. What was in the email was testified to by MS and NS, and many of the other witnesses who dealt directly with the children. Lynn Horder-Miller, Melissa Sayward, Brenda Kennedy, all of them. So anything else that was said was cumulative.
Right, and that gets to another point. I'm just focusing on the excited utterance application here. That you have a child who is telling a third person about what happened to another child. Are there cases that support the expansion of the excited utterance in that circumstance?
I would say the Lukacs case does, because it talked about the brother being permitted. If the point is, which I don't think it was made in the brief, but I think what you're getting at is, was MS talking about AS? Could it still be an excited utterance if it wasn't about herself? Is that what you're
Correct.
asking? And I think the cases would show yes, because it can still be testified to. It does not have to be solely the excited utterance about what happened to her. And it was, when you read Brenda Kennedy's testimony, you'll see how it was so dramatic and lasting in their minds, because it included everything. They were right there witnessing what was happening to AS, and that is still an excited utterance. When a child witnesses violence, that can be the subject of the excited utterance, because it affects their psychological and emotional well-being.
But that's when the utterance is made close in temporal proximity to the event, not the situation we have here where it was several months delay. Am
But
I
the
understanding that
cases-
correctly?
Here's a continuing emotional or physical shock may prolong the impact, making it proper to resort to 803.2 despite long lapses of time.
Where the child is the victim.
Well, but there are cases where it's 7 months later.
Because, but this is the child who is the victim, correct? Not describing what happened to another child.
They're often, like in Lukacs, there's often both, because all of the children are in the same home where all this abuse is happening. And another child may testify about what happened to their sibling. There's no rule against that not being an excited utterance. They were there in the room, they saw it.
And I guess the distinction I'm trying to reconcile is the length of time between what they witnessed happening to a sibling and when they expressed that to someone, and they're using it as using excited utterance as a way to get it in through the hearsay exception. Does that make sense?
Yes, if I
Okay.
understand what you're saying. I've never seen any case that differentiates when an excited utterance, the timeline for when it's allowed in, whether it has to do with a witness testifying solely about themselves or also testifying about abuse to another child. I've never seen any difference. No case that says in this instance it should be sooner in time.
Okay.
And one of my points on all of this is that they were cross-examined fully when they testified at trial, and they were older.
Meaning the two children?
Yes, MS and NS.
Okay. So your argument is that the evidence, that the foster mother's evidence was cumulative because the children testified how they testified, and plus the Mayerson interview?
Yes, a lot of this was cumulative.
Thank you.
And that there's nothing in these statements I mean, I'm saying they were admissible as excited utterances under any of the case law. Did you have any other questions about other assignments of error?
On this one, could you talk to me about the sufficiency of the evidence? Specifically, there's a few that I had questions on. Okay, so with the 29-19-22A charge that involves MS, reading through the evidence and reading through the briefs also, so it looked like the facts that were supporting that charge were her being hit, punishing her with cold showers, isolating her, making her sleep on an inflatable pool float, and withholding food. Now, of those, there's lots of case law saying that affirmative acts need to be charged under B, and that the A section is more for neglect, the failure to act, the omissions. So of those acts, it seems like the only one would be withholding food. Would you agree with me?
That is a failure to act?
That is, yes, that is a failure to act.
The Kate Snyder failed to get MS to allow her to have assessments, physical therapy, occupational therapy. Those were more of those acts.
Okay, the omissions. Okay.
Yes.
And then, so regarding all of that, since it's an F3, the state had to prove that the child suffered, I think it's serious physical harm is the phrase. So what evidence was there that that any of those acts caused MS to suffer serious physical harm?
MS had, for periods of time, was not given food, which can cause pain, hunger pains.
Was there any evidence, from what I read, the evidence about withholding food, at one point, she said, well, they gave it to me after an hour. It wasn't like it was, she went a whole day or longer without it. It seemed like it was only an hour. So,
Another time, I'm sorry.
no, please.
Another time, she said it was a day or two. NS testified that when they would punish her, it went up to 2 days, I believe, with no food. And the isolating in a room, being put in the cold showers, being put in a cold tub until.
Again, those are affirmative acts, though. Those aren't omissions.
Oh, you're talking, okay.
So I'm specifically talking about the A charge, not the B charge.
Do you
So
have the A right in front of you? Off the top of my head, I'm trying to remember what you're.
I have my notes, but I don't have the actual, it's to sum it up, no parent shall, I think it's fail to act, fail to meet their duty of care, protection, support, et cetera. And case law has said that that means omissions rather than affirmative acts. So the affirmative acts is charged under B.
All right. There were a number of times Kate canceled appointments for MS. She outright refused to allow any kind of assessment. I'm repeating myself, physical therapy, occupational therapy.
Okay. So again, with that specifically, the failure to take her to appointments, was there any evidence that caused her serious physical harm?
Not such as an injury. No.
Okay. All right, thank you. Do you have any more questions, Judge Moore?
Nothing.
Okay, your time has expired. Thank you.
All right. Thank you, Your Honor.
Thank you.
Mr. McKenna, you have about 4 minutes, but I'd let her go a little bit long, so I'll give you a little bit of extra time as well.
Thank you, Judge. Your Honors, just briefly in rebuttal, as far as the excited utterances, which is the statements that children made to foster mother Brenda Kennedy, in that Lucox case, which we've been discussing, in the case, it says you can't squeeze hearsay in as excited utterance if there's been reflective thought. And I would simply state again that 2 months and some weeks is a pretty long time that you're getting outside the arena of excited utterance, of contemporaneous observation. That's just not what excited utterance was not designed as a policy to talk about a statement that's that old. And it should not have been allowed in. I think what it comes down to is what the court has asked previously, what's the error? If just assume for the sake of argument it was led in an error. And the error is just because Ms. Kennedy's testimony was so important and so dramatic in describing this incident that it affected the jury. Because once you take, as I said earlier, once you take her testimony out about the excited utterance, you're left with the doctors and the children testifying for each side. Some children testified for the state and some testified for the defense. So her testimony was very important, and I would submit that it definitely prejudiced Ms. Kennedy.
But the jury is free to believe the children. They're free to believe the expert that were presented by the defendants.
Of course, the
And
jury, I'm sorry.
there was evidence to support the defense position based on that testimony, is that right?
There was evidence for both sides. I know that the older children testified for the mother and the father that the home life was good and they were loving parents, et cetera, et cetera. And then you had the testimony of MS and NS saying opposite that.
And it was up to the jury to determine who they wanted to believe.
Yes, of course, ultimately it was. But that's what I'm saying, that the testimony of Ms. Kennedy talking about this hearsay was so important because you had these two equally, how can I say, two equally credible, perhaps, testimony of children who had one different experience for the defense and children who purportedly had different experience for the state. And beyond that, Your Honors, I wouldn't have anything else to say unless there's any questions. Thank you.
Thank you.
Thank you.
Your case has been submitted, and we will issue a timely decision. And if I could have Ms. Conkin. Would you like to reserve time?
Yes, there were 12 and 3.
12 and 3, you got it.
May it please, may it please the court, counsel? I am not going to talk at length about the issue of the children with Brenda Kennedy, but I do want to mention, with regard to the time period leading up to that period of behavior that Brenda Kennedy was allowed to testify about, excited utterances can come in after, like, the immediate event, precipitating event. But in this case, over 2 months had gone past. There was no precipitating incident that would have caused that behavior. In other cases where they've allowed excited utterances or children's behavior and statements to come in after a period of time has lapsed is when there'd been a trigger, like seeing the offender, having someone say, oh, your mother's in heaven, something like that. Nothing like that happened in this case. There was nothing that precipitated their behavior. It was just out of the blue, these children started engaging in this behavior and making those statements. The fact that they were so spontaneous, however, is where the prejudice comes in. Letting her testify to these children just spontaneously and for no reason, with no prompting, no questioning, no one's leading them, no one's suggesting an answer, that's where the prejudice comes in, that they tend to be considered more credible than perhaps statements they gave in an interview or answers that they gave on in trial testimony. And she actually testified. She was the next to last witness to testify. NS and MS had already testified. Cecilia Freehofer had already testified, and their testimony was inconsistent with what they said during their interviews. The testimony was more consistent with what was testified to by Brenda Kennedy in the excited utterance, and that's why it's prejudicial. It bolstered their bolstered their credibility on the stand, when it was clear that their testimony on the stand was completely opposite what they had told Cecilia Freehofer during their Mayerson interviews.
It wasn't completely opposite. I mean, didn't MS testify about what happened to AS, and didn't she also mention, at least partly in her Mayerson interview, some of the same facts? I mean, I guess I'm asking, what differences do you see?
Hold on, I have it written down. Okay. In the CAC, MS made no disclosure that John did anything
Correct,
to AS.
correct, yes.
At trial, she said John and Kate hit AS on the head the day he died.
So you're specific,
There are specific, she didn't mention cold showers or withholding food in her Mayerson interview. And then at trial, she said they made her take showers and wouldn't feed her or AS. In the Mayerson interview, she said AS hit his own head. At trial, she said Kate and John hit AS on the head, hit his head on the wall, and then said they didn't. Then said they did it because they were mad. In the Mayerson interview, she said she didn't know why she didn't live with mom and dad. And then at trial, she said she didn't like living with them. So the disparity between their trial testimony and their Mayerson interviews made the Brenda Kennedy testimony all the more important.
Was the Kennedy testimony consistent with what they testified to at trial?
More, yes.
Okay, so
That's
why?
when the cold showers first came out. That's when, the banging of the head came out. None of that came out in the Mayerson interviews. And the Mayerson interviews were conducted because Brenda Kennedy had reported this behavior.
But it had come out at trial before Kennedy testified,
Yes.
is that right? Okay, so why is that not cumulative?
No, that's what I'm saying. You have two different pieces of information coming out with regard to these children. One, they testified, they were like the second and third witnesses to testify. They testified, they give all this information about John and Kate doing these horrible things to AS. Cecilia Freehofer Hicks testifies later on in the trial. They elicit information that they didn't say these things. They didn't disclose cold showers. They didn't disclose that AS had been hit on the head by Kate or John.
well, I'm looking at my notes here, and it looks like about 28 minutes into the interview, MS indicated that Mama hurt AS.
But not hit him in the head. That's what they were demonstrating with Brenda Kennedy. They were banging their heads or taking a doll and banging her or banging the head. That's where the head injury information comes forward. That's not testified to, or that's not contained in either of the Mayerson interviews. In fact, Cecilia Freehofer testified that she should have stopped the interview of NS after 10 minutes because he was uninterviewable, and yet it continued to come in. So anyway, my point is, that's why her testimony was so prejudicial, and that's why it's in and of itself should be grounds to give these people a new trial, especially John.
And just to make sure I understand, is the argument then that Kennedy's testimony restated the children's testimony? That's what made it impactful?
Yes, it lent them credibility. It bolstered the credibility when their credibility was at issue because of the Mayerson information coming out, that they didn't say these things, inconsistent statements by these children, and then Brenda Kennedy gets to come up and say, oh, within 2 months after the event, this is what they were doing. So this substantiates what they were saying in their testimony. Pay no attention to what they told, Cecilia Freehofer Hicks.
Okay.
Now, the arguments that I was going to focus on, and I was going to argue on it does have. Number one, assignment of error number one, which is improper vouching. Sorry. I raised the issue about Melissa Sayward improperly vouching for the credibility of her mother. Nancy DeBussy, regarding the email, specifically said, were you concerned about the safety of the children? Yes. Why? My mother's not prone to making up stories. That alone might have been okay, but then in redirect, did you think your mother was lying about the yelling? Objection, hearsay, overruled. No. So she's vouching for her mother's credibility, and it's important because Nancy DeBussy didn't testify.
But I'm
All we
sorry, in
have is-
response to that question, isn't she testifying as to her perception of her mother?
She's testifying to her mother's credibility. Does your mother lie? My mother doesn't. Does your mother lie? Did you think she was lying? No, I don't think she was
No,
lying.
I guess that's my, do you think she was lying?
Yeah.
Is different, I think, than my mother's not a liar.
Oh, I think when you're testifying to this piece of information, this document, this statement she made, Nancy DeBussy, do you think your mother was lying when she wrote this? Absolutely improper vouching.
And I guess that's where I'm confused. Did she say, I didn't think she was lying, or did she say, I don't think my mother was lying in that email?
The question was, do you think your mother was lying when she said there was yelling? That was the specific question. And the objection is objection hearsay, or actually it was just objection, and it was overruled. And she was allowed to answer no. She didn't expand on it, it was no, but no, I don't think my mother was lying when she wrote this. Improper bolstering.
Let me ask you this, and I think I asked the other counsel this as well. Does the email go to any element of any of the charged crimes?
Well, if you're saying I want to kill them, yes.
Did she say I want to kill them, or
Well,
did she say?
I thought you asked that question.
I-
I don't remember seeing that in the email. The problem is, and I'll just go back, the email was admitted for the specific purpose of establishing Nancy DeBussy's state of mind. That's it. State of mind exception, typically, with the exception of probate issues, is supposed to be used to demonstrate for future actions. Like, 10 days ago, the defendant said he was going to kill his wife, and then a week later, she's dead. So that statement gets to come in as a state of mind. It doesn't get to come, state of mind doesn't include memories of past events. It's completely forward-looking. And that's what I argue in our brief, that this wasn't it shouldn't have been admitted anyway. But then, the prosecution in closing used it for substantive evidence, and that was the problem. That's what makes it prejudicial. They used it at the very beginning saying, the wheels came off in May. And we know from Nancy DeBussy's email that this was what was happening. There was over-discipline, there was yelling, Kate Snyder was out of her mind, didn't know what to do, she was, overreacting to things. They used it as substantive evidence, not for the state of mind exception that they agreed it was admissible for. And because that was the launching off place in their closing argument, it set the tone that the whole summer was just one big event after event after event of abusive conduct and neglect. And that's why that email is so prejudicial. Now, my argument with regard to the vouching, obviously Melissa Sayward lends credence to her mother, even though her mother's not even there. But the more important one was the Deb Dubé. She was the counselor who treated the children or who counseled the children, provided social services to them during their time with Melissa Sayward for approximately 5 years. This is still my assignment of error number 1.
Yeah, counsel, I went through every single instance and every single citation that you have.
In terms of the question and answer, or?
Yeah, I mean, I went through your list.
Yes.
And I noticed that a lot of these were on cross, and it was elicited by the testimony was elicited by the defendants, and it seems like the exhibit itself with the notes hadn't been admitted or published by that point. It was the defense that had that exhibit published and admitted into evidence and published to the jury. Am I confused? I mean, it's a really long record, and I'm not sure I got every detail right, but I was trying to understand that.
One page of the record was admitted, and that was admitted by Kate Snyder.
Okay.
The testimony, however, I guess to the extent if it was elicited on cross, I don't remember that being the case. The problem I had is, and this was referenced in the Wright case as well, your 2024 case, where one of the issues was Makaroff and whether she testified that her diagnosis was based on solely what the child had told her. And that was considered impermissible vouching. And one of the reasons that it was considered harmless error, one was a bench trial, and two, that the defense had elicited it himself. The problem is, now that we know this, that these were the bases for her, for her opinions, that's impermissible vouching. And my point is, if the defense did it, then it was ineffective. But my argument was it was plain error, because the court should not have allowed that information to be elicited from this client or from this witness, whether it was by the defense or the prosecution.
So, and I'm letting you have a few extra minutes because I'm asking you questions. Your time has expired. So, going through these, like, for example, the first one is that these two children were more confident about what they knew to be true, but she didn't say what that referred to.
Well, she ultimately did.
I mean,
These are all, they kind of like set the stage.
Okay.
Because the next one that I cite is NS suffers from PSD. I think it's from from knowledge his brother was hurt in the home and that it led to them being taken out. Then regarding MS, in my opinion, her PTSD was caused by seeing what happened to her brother and the punitive treatment she received. This is exactly what Makaroff did. She based her diagnoses only on what the children told her.
is it different that the diagnosis was PTSD rather than she was abused? Because I think in the Wright case, the diagnosis was that the child's injuries came from being abused.
Well, but that's not a diagnosis. I mean, the diagnosis is she had an injury. The cause of it is really kind of irrelevant in a doctor setting, the cause of it. Here, the diagnosis is the PTSD. She was treating these children and determining whether they had any type of emotional or mental illnesses or disorders because of what happened, although in the home. And so her conclusion that their PTSD, their anxiety, all the issues that they were suffering from was directly related to what they saw or what they experienced in the home. And by doing that, she was vouching for their credibility, and that's improper vouching. And the reason that it's prejudicial is because they were so inconsistent with their Mayerson interviews on the stand. These two children were the only witnesses the state called to testify that said that Kate and or John hit AS in the head on the day he died. The only witnesses. That's why all of these assignments of error that we have raised regarding their testimony, their statements, their actions with Brenda Kennedy, that's why they're so prejudicial. Because their entire case hinged on their testimony.
Okay, thank you.
Thanks.
On the subject of Deb Dubé, I think the reason the defense published all these, kept asking about all these statements over during cross-exam, and they wanted to publish it, and they admitted it, put it before the jury, was because they were trying to dovetail this with their witness, Dr. Bassman, who was going to get up and testify that Deb Dubé's techniques were not up to industry standards. As I think he also did that with Hicks in the Mayerson Center. But he also said, I think it's very important, Dr. Bassman said the therapist must write down and take notes on the subjective experiences of the child that's being counseled. And that's all she did. That's exactly what she did. she didn't ask to have these statements in her own personal notes be proven anywhere. These were in her notes. The defense wanted to get into it and wanted to explain it. And it was based, of course, she made her diagnoses based upon what the children say. This therapist was not in a position to be going out like Lieutenant Wiltshire and investigating everyone. The therapist listens to the child in these sessions. And talking about, she makes the point that there were so many inconsistencies, but the children were cross-examined in great detail about everything they said at trial, which is when they were 12 and 14, as opposed to the mayor's son when they were 6 and 8. And so all of that was put before the jury, and they were able to discern from the cross-examinations what they felt was credible. Which kind of gets back to another point when I'm talking about the ages of the kids. When they first went to Mayerson, MS in particular, and NS, they used the words terrifying. They were terrified of the Snyders. She was told that they wanted her, this MS was told they wanted her to die, that they said they didn't like her the way she did the other children. Well, okay, so that's at age 6. Then, by the time they testify, she's 14. And Lieutenant Wiltshire gave a lot of testimony about this. Over time, children will disclose more. Children who've been under abuse for a long period of time may not immediately tell everything. Over time, like he said, these were all children with severe disabilities that, they varied, but their mental capacities, their speech, especially with MS, all of that developed over time, so they were able to, they did disclose more, and MS, even eventually before trial, had surgery that helped her speak more clearly. So it's not that, when you talk about inconsistencies between the two, there were very viable reasons for how that developed. And I would look at Lieutenant Wiltshire's testimony about that.
Was he testifying, was it he or she? I don't remember.
He, Lieutenant.
So was he testifying from his own experience? He wasn't an expert, right?
Not in that, but he had met the children over time,
Okay.
and he interviewed them in New York in 2022.
So if I'm understanding you correctly, what you're saying is that the children's testimony wasn't inconsistent, rather it was more complete as they, years later when the trauma was more removed.
Yes.
Okay, thank you.
There were going to be some inconsistencies that were brought out between them all, but those were not major in terms of the entire thrust of this case. And they were brought out by the defense, and they were cross-examined in great detail, which, goes back to, again, Deb Dubé and why the defense wanted to bring out what she had said and what her notes were, because they wanted to try to say, they wanted to use that to say she was not a good therapist. But then Dr. Bassman even did admit, said she was really good. And he said, they said, did you know she's had 5,000 interviews? And he said, oh, I really didn't know that. I had no idea. And then his statement, you must write down the subjective experiences in the notes. The defense said that, and that's what's being complained about now, but that's exactly what a therapist should have done. With Brenda Kennedy, maybe I'm repeating myself, but that the children had said they were afraid of the defendants, very afraid. And it was in December when they disclosed to her, and they were still under, I think, the stress of the severity of what had happened. And it was not until they had gotten away, and Maisie, MS, is trying to describe, like, her fear of the cold showers and cold baths. She's trying to describe what the fear came from, and this is when it all came out. And NS was absolutely in an excited state, excited utterance, when he wanted to jump in and clarify more, probably because of MS's different speech. Sometimes she would sign, sometimes she would try to speak. But I guess I get going back to excited utterances and why they were under such stress, that it was still an excited utterance. With talking about the email, the judge even stated, look, there were at least 3 examples, could have been more, of forward-looking intent in that email, which is why she found 8033 applied. And the statement was my mother was not prone to making up. She didn't say lies. My mother wasn't prone to something. She was answering, it was a response to a question. And that it was not that she was vouching for, but she was actually explaining it. This is why I did what I did. This is why I came to the house. This was why I wanted to see these children. She had been in sync with her sister for years and assumed that whatever Kate was doing was good with the children. But as, evidence starts to mount, she's hearing things, she says, I want to see it in person. And that's exactly what she did. And that's why she went there. The one question, did you think your mother was lying? I put it in the brief. No, that shouldn't have been asked. You can't ask questions of credibility.
Counsel, can I jump to something that I just wanted to touch on? This argument that the trial court erred when it didn't provide jury instructions or verdict forms for count 6 of the indictment with respect to Mr. Snyder, what's your response to that?
The indictment always tracks statutory language, and that's what it did. I have never seen an indictment that then tries to add facts of an actual particular case. The jury verdict forms track statutory language, and the prosecutor went into more detail about what was involved in each of the counts. She had a PowerPoint.
But we don't have record of what that PowerPoint says. Or is that in the record? What is the actual PowerPoint in the record?
I thought it was.
Okay. All right, go on.
Okay, and if you don't, it was described, and then it was tied in with the prosecutor's statements about, and here is what the testimony from each of the kids. And she tied it into child endangering, and she tied it into the felonious assault, the one you're talking about, count 6. And all of that was explained to the witnesses and in the closing argument. The jury instructions there was a great deal of time spent with defense attorneys and the prosecutors, and they were all involved in it, and there were absolutely no objections to it. Defense had a part in drafting this. So that was never an issue at trial. It wasn't an error, it wasn't objected to. There's only this argument now, but I think you'll find that the defense attorneys were a part and parcel of this, and that the record is going to show what happened in count 6 through, if the PowerPoint, unless you don't have it, but the prosecutor was discussing the PowerPoint in her closing, and she's referring to it. And then she refers to the testimony that backed it up.
Okay, thank you.
All right? Any other questions?
I do want to go to another question about sufficiency. And specifically, hold on, let me find my notes about which one I wanted to ask about. Okay, so COS, the baby. It sounds, as the way I read it, the way I understood the arguments was that because this child didn't gain sufficient or adequate weight, he was only gaining between 6 to 8 grams per day, and the goal was 30 grams a day, which is about an ounce. So from that, the doctor diagnosed him with medical and nutritional neglect. So from that diagnosis and knowing how much he was gaining weight, could the jury have made the inference that they were starving him?
Yes. The
Okay.
testimony was also, in that, talking about his weight, with Dr. Kathy Makaroff. There was also the fact that when he was supposed to be, he wasn't even gaining enough weight to be on a waiting list.
Let's put that issue aside for a second. With the transplant, but just in general, based on how much weight he was gaining compared to how much weight doctors said he should be gaining, would that be enough to show the jury that he was not getting enough food and that he was hungry?
Yes, that was so drastic, and with the weight of what he was when he came, the way he ended up with, and it was case law that being hunger pains are serious physical harm. It causes pain.
So there was no, as far as I could tell, and I again, huge record, I might have missed stuff. Reading the expert letter, did any expert ever testify that he would have suffered from hunger pains?
I would believe Dr. Kathy Makaroff testified to it.
Okay, thank you.
Do I have any minutes left?
Yes, you do, you have 2 whole minutes. Actually, you have a little bit longer than that, since I gave misconduct.
Just on the issue of prosecutorial misconduct, nothing that was done in this case, to me, constituted prosecutorial misconduct. It was obviously very, very contentious. And there were a number of things that had happened that the defense had done which would not be the issue of prosecutorial misconduct, but putting the spies behind them, claiming that a Zoom person had phones, all of this. And then the actual complaint was that the prosecutors didn't tell them exactly which exhibit they were going to use, and they tried to call it new exhibits and surprising them. When you go back to Judge Cross's explanation of this, there was no surprise. They were given all of the medical records, but they wanted the state to have gone through them and then handpicked them and said, here's what we're going to use. There was somewhere a statement I read that said the state said, and there were records they said they weren't even going to use. I could find nothing in the record to back that up. The state did try to bring in documents. They would pick out, say, 3 pages before somebody testified. But there was no withholding. And the defense even acknowledged that. And they said, yes, we did have all of that, but we thought maybe that they should have done this. They should have told us exactly what they were going to use. They also said that, well, there was one point where a defense attorney tried to put in 500 pages all of a sudden. And the judge said, no, you're not going to do a document dump. If this was not ahead of time, you can't, if it wasn't brought out in discovery, now's not the time. But everything, if you look at the record, the state it was in discovery through medical records or the police records. And that is in the transcript. That was not prosecutorial misconduct. The one thing where the judge said, gotcha, that does not look good for the state, was that in the lunch break before Dr. Bassman's testimony, the prosecutor came in and said, Judge, we were reviewing all of his testimony over the weekend, and we don't think this report not everything in the report is allowed in. So, yes, that was a late bringing up of this issue. But the judge dealt with it and actually agreed with it. And the defense even ended up agreeing with it and saying, yes, he cannot comment on the credibility of the children. And that was the part of what was in the report that needed to be redacted. But I just think when you read the record, there will be no prosecutorial misconduct. I think the prosecutors were very careful and about what they brought out and very prepared. And this idea that bench briefs, like there was something wrong with it, the defense could write motions and call them briefs the way the prosecutor did. He's kind of old school. Nobody else I know uses that word to say, oh, it's a bench brief. If you file a motion or you want to file case law, that's allowed for both sides.
Is it better practice, though, to file a motion in limine beforehand, giving the defense time to be able to think about it and respond?
And I believe they were. The motions in limine, there were many motions in limine filed and discussed. There was even a place where the defense brought in and said, yes, Your Honor, I just brought this in, and I didn't give you a copy. I don't even have a paper copy. He said I filed my brief, referring to it in the same way. And no, neither side should. Optimally, everyone would be giving both sides plenty of time. Is that my time?
Do you have any more questions?
Nope.
All right, thank you.
Thank you.
Ms. Conklin, you have 3 minutes.
Rather than address each of the comments that was made by counsel, I'm just going to refer to our briefs. I think we adequately just address the issues specifically of the improper vouching, the inadmissible evidence of the children's actions and statements to Brenda Kennedy. One of the issues that I didn't get a chance to talk about was the trial judge's abuse of discretion in finding these children competent to testify, and that the interview that she conducted without notice to the defense and without any defendant's attorney present was wholly inadequate under Ohio law to determine whether these children were in fact competent. And the fact that during their testimony, they demonstrated clearly that they were not competent to testify by saying, yes, no, I don't know, I don't remember, and completely demonstrating their inability to remember with any clarity acts that occurred in 2016, and then to communicate what their memories and their observations were with any clarity and comprehension. There was never any clear and establishment of their understanding of the difference between a truth and a lie at the level that it was necessary in this case. If I
There
said
was some back and forth about the difference between a truth and
yes,
lie,
but it was
right?
all. If I said my robe was purple, would that be a truth or would that be a lie? That would be a lie. And why is what happens when you tell a lie? I have to make it right. This is NS telling the judge in chambers. Well, what does that mean? I have to apologize. That childlike, as you would expect of a 12-year-old, that childlike understanding of what it means to tell a lie and what happens when you don't is not the same standard that you need to understand when you're testifying in a court of law. This isn't I didn't take the last cookie, and then finally admitting that you did and saying, okay, I'm sorry, and then being absolved of all responsibility. Saying I'm sorry isn't enough at this level of the proceedings. Saying, oh, I made a mistake, I didn't really mean to say that, 5 years later, I'm sorry, that doesn't work as a defining basis for finding the child understood the importance of telling the truth.
Doesn't it demonstrate, though, that the child recognized that there was something to be sorry for in not telling the truth?
Yes, but the problem is that he thought that would solve the problem. That's the problem with children and their understanding of truth and lies and what the downside of telling a lie is. The downside of telling a lie in open court is perjury. And it's the possibility of having someone go away to prison for something he didn't do. They don't understand that. They were not asked any questions during the trial court's interview of them as to what their memory was of the time frame that these events supposedly occurred, 7 years before. That's what the law says you're supposed to do. You're supposed to determine whether they are able to remember events from the time period in question. Her questions were like, what did you have to eat last night? There was no determination that they had any ability to remember what happened. None. And their understanding of what her role was, you bang the gavel. So that's set forth in our assignment of error number 4.
I have just, you're out of time. I have just one, hopefully, quick question. Hopefully. So, in the 7th assignment of error, the prosecutorial misconduct, the 3rd issue was the sabotage tactics, not filing a motion to eliminate, instead filing
Day of.
day of. Was there ever a point where defense counsel, trial counsel asked for a continuance to be able to properly
No.
respond? Okay,
No,
thank
but he
you.
did raise, trial counsel raised this as an issue basically throughout the trial. As, and, you know, the fact that they disclosed medical records as exhibits, there were like 16,000 pages of medical records. And so to say on the day of a witness's testimony, we're going to pull from this stack of medical records, these 3 that we're going to use today, is inappropriate.
Okay, I was more talking about the day of
And, yes, no, I know.
motions, yeah.
I get that. And then,
Okay.
yes, especially with Dr. Bassman.
Okay, all right, thank you.
Thank you.
Thank
All right,
you.
this case has now been submitted, and we will issue a timely decision.